And we are now getting into another topic that unfortunately is one we encounter all too frequently these days. And we're fortunate to have with us today Sir Robert Klotz, who has, as you probably know and certainly will see, has thought extensively about the problems in this area. So I'd like now to present Robert Klotz, who will speak on the subject of bankruptcy problems in family law.
Good morning. Can you hear me at the back? No. Hello? Right, good morning, ladies and gentlemen. I am humbled by this crowd. My area is bankruptcy and family law. In my experience, the attitude of family lawyers to bankruptcy is hostility, fear, fury, or despair. Hostility when the bankrupt, or when the husband, shall we say, goes bankrupt on the eve of trial, and instead of a rotten spouse before the court, you have to fight with the trustee. Fear, because bankruptcy can preempt spousal rights in many cases. Fury, in the case of a malicious spouse who destroys him or herself while just trying to destroy his or her partner. And sometimes despair, because bankruptcy can be abstruse and foreign. An example of this attitude is the title of an article that was written in this area by Tony Merchant called The Bankruptcy Dodge. Bankruptcy is not always a dodge, although it can be. In my experience, most bankruptcies, particularly these days, are legitimate responses to legitimate financial failure. In my experience, most spouses who go bankrupt, even in the middle of a matrimonial dispute, do not do so maliciously. They do so because of their credit problems or their financial failures. Now, there are lots of problems in this field. First of all, the Bankruptcy and Insolvency Act is not a complete code. It's unclear how it meshes with the different family law acts, and in particular with the FLA. In many of the family cases, the bankruptcy issues are argued by solicitors who are unfamiliar with bankruptcy principles before judges who are also unfamiliar with those principles. And so we get strange results and very strange precedents. The proper case law is not always brought before the judges, and that's partly a problem of the terrible indexing that makes it difficult to do research in this area. There's also a lot of inappropriate application of precedents from other provinces or FLRA cases. And a lot of these precedents have no application to an equalization scheme, but sometimes that's lost in the confusion. The other problem, of course, is that people who need this advice often can't pay for it. Now, the object of my paper is, first of all, to give a perspective on how bankruptcy works. And that's, I guess, part two, the overview of the bankruptcy proceeding. And I'm not going to discuss that, but it's there for you to read. When bankruptcy does intervene, it is important to understand the scheme of how bankruptcy operates so you can see where the family case fits in. The second purpose is to explain briefly some of the principles that apply in bankruptcy law. And that's part three of the paper, although I see it's numbered 2. Called Principles and Provisions of Bankruptcy Law. And in short, some of those principles are that the trustee steps into the debtor's shoes and has no greater rights than the bankrupt spouse did unless the Bankruptcy Act specifically provides otherwise. Next principle that you'll note is the trustee's duty of fairness from a decision called Ex parte James. It's similar to constructive trust principles. The trustee can't take advantage of legal rights when to do so would be dishonest or unfair. And that principle is very limited in scope. The third principle that I make mention of is paramouncy. Bankruptcy is paramount federal legislation, where it conflicts with provincial legislation such as the Executions Act, the Creditors Relief Act, or the Family Law Act. It is paramount. However, bankruptcy also incorporates much provincial law. So it incorporates, by reference, provincial rights, to some extent family rights, and so on. That makes it challenging. Now, the heart of the paper is the set of 8 case studies. And I set it up this way to be, in effect, a practical guide rather than a theoretical treatise that no one wants. I can't give all the answers. Many of these questions have no answers. But my object was to suggest ways of approaching the common problems that, that family lawyers run into. A lot of these areas are dealt with in further detail in an article I've written that's mentioned in footnote 2, and as well in a book that's coming out in God knows when, whenever I finish it. Let me start then with the first case study, which is on page 12. The wife holds a judgment requiring the husband to pay spousal and child support and a $200,000 equalization payment. Property has been divided. The husband is in default. The sheriff seizes and sells the husband's car and is about to pay out the wife when the husband files for bankruptcy. What is the effect of bankruptcy on the wife, and what can she do? All right. The first issue here is support. Support is not provable in bankruptcy. It is not stayed or affected by bankruptcy. It continues. Enforcement can continue. That's fine as far as it goes. However, all of the bankrupt's property vests in the trustee. So while the support claim can continue, it can't claim any priority against any of the bankrupt's property that vests in the trustee. That's basically everything, except for exemptions. The only asset that's usually left for support is the debtor's wages, or perhaps the pension, which doesn't vest in the trustee. So in this case, the sheriff has sold the car, has money in his hands, the trustee gets the money. The only way the wife can get the money is if the sheriff has actually paid the money out to the wife, in which case she can keep it. But anything short of that, the Bankruptcy Act specifically says the trustee gets it. Exemptions. Bankruptcy incorporates provincial exemptions. So the trustee doesn't get the bankrupt's pension, doesn't get certain kinds of RRSP funds that are life insured, unless this judgment that the wife has gave her specific rights in the pension, or specific rights in the RRSP, or specific rights in the exempt furniture, the bankrupt keeps them. That can cause problems. In some cases, the wife can consider moving to annul the bankruptcy. This is particularly useful if it's a malicious bankruptcy. The wife is the major or the only creditor. The cases are extremely difficult if there are any other creditors at all. The annulment will not succeed, even if the sole motive of the bankruptcy was spite or the sole motive was to frustrate the wife's claim. If there are bona fide creditors, annulment will be refused. So while it would be delightful to get rid of the bankruptcy, it's a difficult onus. What else can the wife do? She has a judgment for $200,000 for equalization. That is a debt. And just like any other debt, you can prove it in the bankruptcy by filing a proof of claim. It's liquidated, it's $200,000. Fill out the proof of claim and file it. Vote in the bankruptcy. Pursue the same rights that all other creditors have in the bankruptcy. What do those rights include? The right to have the trustee examine the bankrupt as to his or her assets, in this case his assets, and pre-bankruptcy transactions. The right to pursue improper preferences or fraudulent conveyances done prior to bankruptcy. The right to use the powers of the Bankruptcy Act to look for hidden assets. And there are all sorts of criminal or quasi-criminal provisions, including RCMP involvement, that are available once bankruptcy intervenes. The wife is entitled, having proven her claim, to receive a dividend on her claim, the same as with all other creditors. In many cases, this dividend is minimal or zero, but in some cases, it's significant. The equalization claim is released by the bankrupt's discharge. So unless the wife can get some assets into that bankruptcy for the purpose of getting a dividend, or unless she can get a good discharge order, that claim is gone, subject to any dividend that's received. And that brings me to the last remedy, and that is to oppose the bankrupt's discharge. Now, having a support claim is not sufficient to oppose the discharge. You have to have an equalization claim or a property claim of some sort. The discharge is automatic after 9 months, generally. So you have to send in a notice within that time to the trustee, and then in this case, the wife will be entitled to go to court and have a judge rule on any terms or conditions to be imposed on the husband's discharge. Unless a condition is imposed, the husband will be discharged, the claim will be gone. If there are many creditors, the rehabilitation of the bankrupt is a key principle, and it may well be that no condition will be imposed. Most people these days have lost a lot of money. Bankruptcy is a legitimate response to financial pressure. The purpose of the Bankruptcy Act is to help an honest debtor attain some rehabilitation, and that purpose is important. So if there are lots of creditors and the wife is one of many, there will be an order, in all likelihood, imposing modest conditions or no conditions. What about a single creditor bankruptcy to avoid a spousal claim? Well, here the courts are prepared to listen and to make a serious discharge order. And in this paper, I've reviewed what seems to be, to some extent, a rule of thumb, that is to make a 50% discharge order. Bankrupt has to pay half of the equalization claim. Now, that doesn't mean pay half of the equalization claim to the wife. Whatever's paid has to be paid to the trustee to be divided among all creditors, even if the wife is the only one opposing the discharge. So the judge can make a 50% condition, and in the cases, sometimes that 50% condition has been imposed in dramatic circumstances. And one is a case that I was involved in, Ree Matthews, where the husband was making about $20,000 or $25,000 a year, and he was ordered as a discharge condition to pay half of a $700,000 equalization judgment. That will take him at least 20 years to get out, and he's about 58 years old. The facts are extremely unusual in that one, but there are other cases that grant a 50% discharge condition. You have to be careful about destroying the bankrupt spouse through the discharge order, and the judges, at least in a number of these cases, haven't been too concerned about that. They are prepared to visit very harsh consequences on the spouse that tries to evade a matrimonial judgment. All right, the next case study, number 2 on page 17. A separation agreement requires the husband to pay the wife $40,000 in 8 $5,000 installments over 2 years, and to make all mortgage payments on the jointly owned matrimonial home and an investment property. How can the wife enforce these obligations if the husband declares bankruptcy? If these obligations are in the nature of support, support survives bankruptcy. If these obligations are in the nature of equalization or property division, they don't survive bankruptcy. They have to be proven and entitle the wife to a dividend. What happens when you can't tell what they are? And of course, many agreements don't specify what they are. They just call for a payment, and court orders are the same problem. The court has to look at the agreement or look at the court order and try to figure out what it is. If it's in the nature of support, it survives. If it's not, it's discharged by bankruptcy. Call the matrimonial lawyers who negotiated the agreement or who appeared before the judge. What did the judge say at the pretrial? Look at the correspondence between the lawyers. Look at the agreement itself and try and figure out where this clause is. Is it in the support section? Is it in the property section? Is it ambiguous? Would a support order have been granted had this particular lump sum not been granted? If it's an indemnity obligation, is it an indemnity that pertains to contractual or equalization matters, or is it an indemnity that pertains to the wife's ability to maintain herself, such as to stay in the matrimonial home? Look at the fine wording of the agreement. I had one where the word a lump sum for support, the words for support were crossed out. That was bad, but all the other circumstances were good. So we got that one. That was support. Once again, it's the circumstances. If you're negotiating the agreement, bear in mind that everyone goes bankrupt. So you have to characterize your agreement or your lump sums clearly, if you can, if it's something that's worth negotiating, clearly as support or not. If you can't get that kind of clarity, at the very least, keep your support rights open until all the cash payments under the agreement are made. By no means should the support rights be foreclosed on the basis of future receipt of money, because if the party goes bankrupt, you can't apply to vary support. The third case study. I might even get finished all 8. Page 19. The spouses separate, with the wife and children remaining in the jointly owned matrimonial home. 1 week later, the husband files for bankruptcy. What happens? Can she stay in the house? To whom does she owe equalization? All right. The first question is, who owns the house? Title is joint. That's legal title. Of course, that doesn't speak to equitable title, and you've heard this morning about constructive trust and so on. Those principles apply in bankruptcy. The wife's first job is to prove that she owns the whole house because the husband's half was held in trust for her. She can make that argument. Bankruptcy does not prevent it. She may have to get leave of the bankruptcy court, usually a formality, in order to make that argument. What's different about the bankruptcy context is usually the other spouse fights hard to avoid that kind of constructive trust or resulting trust argument. As soon as bankruptcy occurs, despite the acrimony between the spouses, both spouses usually agree that the wife owned the whole house. Because if she owns the whole house, his support obligations are reduced. If she only owns half, he has to pay some more support. So it's in his interest always to agree with her, and for this reason, some of the case law says, be very careful about this kind of evidence. That being said, this kind of evidence is generally accepted because the courts are sympathetic in these circumstances, especially where the matrimonial home is involved. If there are no trust rights, if they are truly joint owners, can the wife ask the court, by way of support or equalization or any other way, to vest his half in her? No. No, no, no. There are a number of cases that say this quite clearly. There is a recent unreported case, soon to be reported, a wacky case, that says yes. The state of confusion and error that led to that, there had to be 3 separate mistakes made in 3 separate court appearances, and they all occurred together. That's the Callan decision, and I'm sure you'll hear about it eventually. It says yes, but it won't be followed, I don't think. This brings me to a philosophical point, I suppose. Bankruptcy cases love the concept of certainty. Bankruptcy law is designed for both commercial situations and these kind of family cases, although it's more tailored to the commercial. Family law loves justice and equity, and that's why so many of these conflicts arise. The case law is clear that the wife can't have the court vest an interest after the bankruptcy. That's not to say that family courts won't do it and muck up the case law. And it's always a challenge to predict what will happen because the judges, particularly where they're given inadequate precedents and particularly where there's strong motivation and strong unfairness and desperate people in desperate straits, will probably do what's right. That's what makes it difficult to really predict. But at least on the state of the case law now, it can't be done. That's not to say you shouldn't try. Next, equalization claim. At the date of separation, which is 1 week before the bankruptcy, the wife owned half the house. Let's say it's $1 million house. The husband, a week before his bankruptcy, probably had 0 NFP because his debts probably exceeded his assets. So, subject to the bankruptcy consideration, he's entitled to equalization of half of her worth, half of her half of the house, $250,000. Is that his? Or is that his trustee's? Can she make a deal with him, or does she have to make a deal with his trustee? The leading case in this area is from 1986. It's an FLRA decision. It's unreported. It's called Re-Bosveld, and I've given a discussion of it here. I've argued in an article that it's wrong. The Court of Appeal just ruled on the point in a case called Re-Blows, and I'll give you the site, BLOWES. It'll be reported soon. 1993 WDFL 1379. And they said basically Bosveld's right. The problem is, of course, they were never told about Bosveld. They didn't see a copy of my article, I've been told. They were told that this was terra nova. There were no cases on this point. Which is, of course, not correct. What Bosveld says is, If someone prior to the husband's bankruptcy had commenced an equalization claim and it was outstanding as at the date of bankruptcy, and there had been a permanent separation, then as soon as he goes bankrupt, boom, the equalization claim vests in the trustee, and the wife has to deal with the trustee. But if no one had commenced an equalization claim and the husband goes bankrupt, it's still his claim. He can go through bankruptcy, get discharged, and then start his application for equalization. And it's still his, as long as no one starts the equalization claim either before bankruptcy, so it's ongoing on the date of bankruptcy, or during bankruptcy. Blows doesn't deal with that fine point. It simply said, in a case where the wife had commenced prior to her own bankruptcy, Blows just said, it's the trustees. And it didn't get into that fine point about whether it was the trustees because an application had been commenced or whether it was just the trustees because it was the trustees. But I think Bosveld is still the law, particularly since the Court of Appeal did not know about it. The critical question is whether anyone has commenced an equalization claim before bankruptcy. So, if there's any chance that anyone's going to go bankrupt, don't start the equalization claim until you've thought about it long and hard. If you're the wife and you commence an equalization claim against the husband, you're going to be dealing with his trustee. If you're the husband and you're about to go bankrupt, you are giving up an asset which is of great value to you once you're discharged, and the trustee will get it. So there's a lot of negotiating to be done between the spouses. Either one can pull the trigger and give the money to the trustee. Both of them have an interest in not pulling the trigger and negotiating. They're entitled not to pull the trigger and to negotiate. If you pull the trigger without knowing the consequences, you will certainly regret it. If you start an equalization claim and it's outstanding on the date of bankruptcy, in my view, you can't withdraw it or dismiss it. It's vested in the trustee. So once it's done and bankruptcy intervenes, it vests. All right, so let's assume now, still on this question number 3, the wife owns half the home, the trustee owns the other half. Apart from equalization questions, can she stay in the house? Trustee is a half owner, trustee wants to sell the house, wife wants to stay because she's got little kids. And the case law imposes a hardship test. Are there young kids? Is it inconvenient to move? Can she afford to buy another house? And those are familiar to all of you, I would assume. And those principles still apply. And I've outlined some of them, and the case law is there. I think Kutchenreiter and other cases that are briefly mentioned in the article. Courts, bankruptcy courts, and regular courts like to keep wives and kids in the family home. The fourth case study. The husband holds sole legal and equitable title to the matrimonial home. He deserts the wife and kids and soon files for bankruptcy. Can his trustee force her out of the home? And just before I get into this, I do my very best to be gender neutral here. The fact is that the general paradigm is the husband who goes bankrupt and leaves the wife and kids with the problem. However, it is not the sole paradigm, and indeed there are many instances that I've encountered where the opposite occurs. The problem is that so many of these problems are abstruse that I've picked a spouse for the purpose of case studies, and I've picked a spouse that represents the norm. All right. This is a question that raises whether or not the wife has possessory rights when no one owns the home, because the trustee now owns it. And this only occurs, 5 minutes. This only occurs after she's tried to establish a trust entitlement and failed. Because if she can establish a trust entitlement, she's a half owner, she gets the hardship test. So she's tried that argument and she's failed. The trustee owns 100% of the home. The case law is very unclear on whether she can stay. Section 24 says that the court can make an order regardless of the state of ownership of the house. Does that mean when neither spouse owns the house? I don't know. There is a tendency in the court, as illustrated by other case law, to expand the wife's possessory rights beyond those that I believe were intended by the legislation. And the Bank of Montreal and Bray case is one such example that's briefly mentioned, also a poorly reasoned case that's under appeal. So who knows about that one, but it's certainly worth a shot. The fifth case study. The husband is worth millions, jointly owned house. There are no kids. The spouses separate and proceed to litigate. The home is sold and the proceeds are held in trust by one of the lawyers or both pending the trial. Just before trial, the husband's business fails and he files for bankruptcy. What happens? Well, here the husband owes the wife a huge equalization claim. Obviously, apart from bankruptcy, she's going to get all the money that's being held by the lawyers. But the trustee intervenes and claims half. Claims half the money because the house was jointly owned. This is the Burson case that may be familiar to some of you. And Burson said the trustee gets half, even though, had the case gone to trial, the wife would have gotten it all. Because bankruptcy severs the joint tenancy and divides the money down the middle. The wife can claim as a creditor. There are solutions to this problem, and I briefly mentioned them. First of all, the parties can agree to pay the money into court, and there are lots of cases, there's some lack of clarity here, that say money paid into court protects it in favor of the ultimate winning party in the litigation. There is an equitable charge argument that can be extracted from some of the cases that wasn't dealt with in Burson. The respective lawyers and the parties can create an express and formal trust. In effect, take this money, instead of just holding it, create a trust document, call it the Smith Family Trust for purposes of matrimonial dispute. Give it the works, and that then may have some intrinsic or extrinsic validity. Put together a security agreement that one or both spouses can sign, securing rights against that fund to one or both of them, depending on how the litigation goes, and register it. And finally, request that the court grant a charging order or force one or both of the spouses to grant security over that fund. And in many, if not all of those ways, that those rights to the property can be protected pending trial. Number 6. I'm pressing my luck. 2 minutes. The home is jointly owned. The husband is on the verge of bankruptcy. The spouses separate and commence negotiations through their solicitors. He proposes to give his half of the home to the wife in lieu of paying support. Can he? This is the problem of collusion. And the case law says, at least at present, at least in Canada, that you can make a deal and give the wife the half of the house as long as both sides are negotiating in good faith and it's done at arm's length. Of course, it's in the interest of both spouses to do this. The risk of collusion is high. The cases say that as long as there's litigation outstanding, as long as the spouses are fighting and there's something going on, you can do an awful lot. The cases perhaps go too far, but once again, the courts want to help the wife and the kids, particularly if there's support problems involved. It helps if you get an opinion that the deal is okay, and it particularly helps to get court approval. And my sense is that courts will grant approval to protect support rights. I'll deal with the last one for just a second, second last one. Case number 7, the wife has $400,000 in debts. Her only asset is a $1 million pension. The husband has nothing. What happens? This is very tricky. In the husband's bankruptcy, his pension doesn't go to the trustee. He keeps it. He keeps it during the bankruptcy and he keeps it after his discharge. But the equalization claim gets released by his discharge. There are 2 ways to get the pension: through support. Bankruptcy doesn't affect that. Don't worry about it. And through equalization. If you wait until after the husband is discharged, you can't get his pension, because equalization is discharged and pension splitting is a remedy for the equalization debt, which is now gone. So you have to split the pension before the husband's discharged. You can't just ask the court to split the pension, because all actions against the husband's property are stayed by the bankruptcy. So first you have to get an order from the bankruptcy court, usually a formality, to proceed against the husband for ABC, including D, the pension. And then you have to get your pension split before his discharge, which is 9 months from bankruptcy, usually, unless you oppose the discharge and, as a condition, extend that time for pursuing the pension. This hasn't been done in Ontario. As soon as I'm involved in a couple of cases where we're moving towards it. As soon as the precedents are around, they'll be publicized. In the meantime, there's the Schroeder decision from Saskatchewan, which is not applicable but is sure to cause lots of confusion. In conclusion, I hope these case studies help. Particularly, I hope the last one that I didn't get to is clearly written. I'm most interested in receiving copies of any decisions which any of you obtain, because I do want to help this area acquire some sort of clarity and certainty. And lastly, thank you all very much for listening.
Thank you very much, Robert, and I apologize to you, as I do to the other presenters at this time, for having to impose these time limits. All of you should realize that in addition to the materials that you've been presented with at the registration desk, you will be receiving the typical blue book of the special lecture series. Now, that'll go through quite a bit of editing and is not likely to be published for some time. So in the meantime, you have the materials in your binder. In addition, when Carol Rogerson's paper is completed, that will be sent out to you as soon as we have it, together with the Robinson decision. Now we move on to the next area on our program, which is about marriage contracts, and Jerry Sidvari will lead us through a discussion on attacking and defending marriage contracts. Jerry?
Thank you, Jim. I'm sorry I can't stay. After what I've just heard, I think I'd better rush back to the office and fix up 50 of my files. Very scary stuff. And here's some more scary stuff, marriage contracts. I find marriage contracts personally fascinating creatures of statute, but I believe that they are a family law lawyer's dream and nightmare. They are a dream because they do afford great opportunity for creative negotiating and creative drafting, unlike a separation agreement, which is 90% rote and fill in the blanks. I'm taking some liberties there. A marriage contract is nothing like that, or it can be exactly like that. It depends on what the parties want. And most of the time, they don't know what they want. It also is one of the few times a family law lawyer can actually bask in the reflected happiness of clients as you assist them in at least a happy beginning of their relationship, come what may. However, these are also nightmares because, as the flip side of my comment just made, you also run the risk, perhaps not a legal risk, but a personal one, of breaking up the relationship before it begins, or accelerating a separation because of the stance that you take on behalf of your client acting in his or her best interests. But more significantly, from a legal standpoint, the nightmare is that the odds, I think, over the next couple of decades are quite good that anyone who negotiates and drafts a marriage contract will end up in court either as a witness, which is bad, or a defendant, which is worse. And these two aspects of marriage contracts, in my view, stem from the same causes. Firstly, the open-ended nature of a marriage contract as contrasted with a separation agreement. And when I talk about marriage contracts, I'm also including cohabitation agreements, but not specifically mentioning them. They are open-ended because, as you know, you can deal with one aspect, one property, one debt, or all of them and everything in between. That's the substantive scale. But as well, the other primary variable is time, because you don't know when the rights that you are creating, if they are to click in, to crystallize on marriage breakdown, including death, you don't know when that's going to occur. Unlike a separation agreement where you're sitting there and you can calmly, coolly assess your client's rights and obligations and give advice and negotiate within that framework. In a marriage contract, are you talking about rights that will perhaps crystallize next year, 5 years from now, 30 years from now? Will they have children if they don't, at this point, what obligations, what other assets and liabilities will exist at that time that you're not covering or that you're covering but you're unaware of it. Just as an example, let us say that a client has a particular asset that he or she wishes to protect. That's what they come in and say to you. I want to protect it. What does that mean? It can mean one of dozens and dozens of things, as far as your imagination and your client's imagination will take you. And because of a point that I'll get to later, that the key to a valid marriage contract, to try and repel the attack that may be coming later, is to ensure that the client understands the nature and consequences of everything in the contract and everything that's not in the contract. Because of that, I think you have an obligation to spend a considerable time with the client outlining the possible ways to, say by example, protect an asset. Doesn't matter what the asset is, you could exclude a class, or you could exclude a single item. You could exclude it for all purposes, including calculation of support rights. You can try that. I'm not sure that it'll work. You can exclude it simply for uses or the purposes of Part 1. You can exclude it including income. You can exclude it with respect to enforcement of judgments by the other spouse. You can exclude it entirely or something less than entirely. You could adopt some other statutory regime rather than simply excluding it. People might decide, if they knew that this was an option, to pick some other province or state's property regime. I'm not suggesting you have to sit there for 14 hours and go through 75 different sets of laws, but there are some common threads that I think you have to explain to a client before he or she finally settles on what they want to do to protect it. They could choose the Family Law Reform Act, go back to that if they thought that it was appropriate. They could fix the Family Law Act as the statute and ignore what may be future amendments that we've all heard rumors about. So they will know where they stand, but not necessarily vary from the current law. They could deal, with respect of this hypothetical asset, only with ownership, possession, and consciously not exclude it from the actions of the Family Law Act. They could do all of these things in combination over differing periods of time. One regime if a marriage breakdown occurs after a year, another after 5 years, and maybe no contract at all after 10 years of happy marriage. It could self-destruct. The point is that you have to, I think, cover these with the client in some but not exhaustive detail. The client will hopefully have some idea after you start in and describe the range as I have, what he or she really is after. But it's not an easy task to ascertain. The second cause of the dual nature of marriage contracts, in my view, is that often, not always, but often, there is an inequality of bargaining power. And your role, if you are acting for the person who has less financial or emotional power, is by acting properly to provide true independent legal advice which will counteract that. Most often, one party has an asset either in existence or anticipated that he or she wants to protect, and the other person doesn't. And if this is done in the middle of a marriage, then you're dealing with existing rights, which you can ascertain at that moment on the assumption that the marriage ends, and you then can calculate what the entitlement would be, and you then can advise your client what he or she may be giving up through these various modifications. But if you are at the beginning of the marriage, where the parties have no rights with respect to each other, unless they've been cohabiting, but assume they haven't, then it is a much more difficult proposition to assess and describe to your client what his or her rights might be, given a whole host of assumptions at different times in the future. Many family lawyers, for these reasons, refuse to negotiate marriage contracts, and I guess I can't blame them. But when it comes to protecting yourself and your client, and perhaps that's the wrong order, protecting your client and then hopefully yourself, from a contract which is susceptible to attack, it is best to go straight to the statute and take a look at what means there are available to parties to attack these. And of course, this is contained in subsection 56(4) of the Family Law Act, and you don't need to turn it up, but I want to make a few comments about each of these paragraphs. A court may, on application, set aside a domestic contract or a provision in it. So right off the bat, you have the question about, or concern raised, when you're dealing with several rights or several properties in a contract, whether you need to consider right off the bat which of these elements are fundamental terms, because the court someday down the road might, for whatever reason, wipe out a provision in the contract and leave the rest standing. And will your client be happy if he or she loses a right or obligation but is stuck with the rest of them? And consideration should be given to declare either an entire package, and if any provision goes, the whole thing goes, or set your priorities about what is fundamental and what isn't. I don't think that's done very often. Paragraph A allows the court to set aside if a party failed to disclose to the other significant assets or significant debts or other liabilities existing when the domestic contract was made. Raises an interesting question. When you're negotiating a marriage contract in the midst of a marriage, does that mean that if there is a failure to disclose assets and debts that existed at marriage, which took place some years before, so it's not at the time when the contract is made, this provision, this paragraph, is not available to the court to use to set aside the contract? I think that argument could be made, but because of the wording of paragraph B, it probably would be to no ultimate avail. But the question of contingent assets is raised as well, because the wording is not property, which is a defined term in Part 1 and includes contingent interest in property, but it's assets, which is not defined. And my interpretation of that is that they must be real assets in which you actually have rights at the time of the contract and not contingent. I don't know whether B, which I'm just about to read, will let you get away with that one, but it's worth thinking about. B is the key. The court can set aside the contract or provision if a party did not understand the nature or consequences of the domestic contract. To understand what it means requires more than just understanding the bare words. As I said earlier, you must understand, your client must understand, based upon your advice and explanation, what is dealt with, the ramifications over time, and what isn't dealt with, and what flows from that. That's your job, and that's the tough part. And I'll come back to it just after I describe or read C, which is setting aside otherwise in accordance with the law of contract, fraud, duress, undue influence. I suppose public policy might fall into this category, in certain kinds of mistake, inequality of bargaining power as described in my paper in limited circumstances. Now, the nature and consequences of the domestic contract, of the marriage contract. This is where the requirement of full disclosure and independent legal advice comes in. Even though they are not statutory requirements, it is clear to, I think, all of us who have anything to do with any domestic contracts, and that includes marriage contracts, of course, that disclosure is necessary in order to explain what your client may be giving up. On the assumption that an asset is being protected or a class of assets is being excluded, along those lines, you need to know what it is, how much it's worth, how much potential growth there might be. And the real problem with negotiating marriage contracts is that the clients, both of them, rarely have the time or the inclination to spend the money to allow you to obtain the degree of disclosure that you would like in order to feel comfortable in fully describing what the nature and consequences of the contract are. And it's not infrequent that you have days, if you're lucky, weeks, but rarely months to negotiate these contracts, particularly if it's not an existing marriage but one that's about to take place. You know, they like to come in on Thursday morning and tell you that I'm getting married Saturday and here's a draft. What do you think? If you can do anything about putting off the wedding, I don't know whether you should suggest that or not. And if you really don't have any time to properly negotiate and you're just there to explain what this piece of paper means, but you can't even make suggestions to the other side for change, for improvement, for your client's best interests, I don't think you can give independent legal advice. I don't think you can actually sign a certificate saying that the person across the table from you is signing voluntarily and understands the nature and consequences. I think you have to back right off. You'd only be getting your client in trouble and yourself in trouble. Let us assume you do have enough time. The other problem of lack of inclination of the parties to actually give you this full disclosure is one which I think you have to deal with and make compromises about. You cannot expect two parties, let us assume that one is expecting to be involved in a family company, but right now doesn't have any significant means, or there's a trust fund or something. And other than that, the two of them are working, making modest incomes at this time, and don't want to go out and spend $10,000 on valuations and $10,000 on legal fees. They just want, and both sides agree, that this asset should be excluded from their legal relationship. I don't think that you would be doing a proper job, and I don't think it's necessary in order to do a proper job and protect your client and yourself, to say, well, I'm sorry, I won't take the case unless you spend the $20,000. You have to make a realistic assessment of what you need to know. And that will vary with the nature of the assets, to a certain but lesser extent, the time that you have to deal with it, and the means of the parties. It is, I suggest, often sufficient to simply have the representation, which is built in as part of the contract, of the party as to the extent of assets and liabilities and their values, rather than valuations and lengthy investigations and disclosure. This isn't a separation agreement, and if for no other reason, if you put them through all these hoops, you may well impact on their ability to buy a house, if nothing else. They won't have any money left. That's not what they're after, and I don't think that's what's required to protect this contract from attack. However, it is probably wise to advise the client in writing that he or she does have, if not the right, because if they're not married, they don't really have rights to compel production and disclosure, but you can tell them that it is advisable and an option open to them to request more complete disclosure. But for these reasons, as you set them out in your reporting letter, your instructions were not to spend that time and money and follow that route. I think if you back off acting in those circumstances, you will be not only letting the client down, but the profession down, because these people do need assistance. And somebody has to put him or herself out to take what is still going to be a risk in acting for that client in these circumstances. The important thing, well, there's lots of important things. I don't know what's the most important thing, but you have to take the time to ascertain the client's goals. What do they really want? Because I've given you one example where they want to protect a particular asset. That's fine. They're not often clear about their goals, and they aren't sure what can go into a marriage contract and whether it can deal with more than just marriage breakdown, and of course it can. So you take the time in the initial interview to describe all these possibilities and find out what they really want. And then you must have some real negotiations. You should, and I think no matter who's drafted the contract, you should have some comments about whether it's a little one-sided here or there and can be improved. You can try to negotiate. If the other side refuses to negotiate and your client says, I still want to sign the contract, you've gotten adequate disclosure, you are sure that this is what the client wants, you've warned the client about well, it possibly being a bad deal if certain things happen over the next 25 years or more, then I think you're still in a position to give the certificate of independent legal advice. It's also important, and this is part of the dreamy aspect of marriage contracts, to draft in clear language. You are given, as I said, a wonderful opportunity to exercise your drafting skills creatively. There are very few marriage contracts I've ever done which are patterned more than maybe 10% on a previous contract. Everyone is different, everyone meets a different set of clients' needs, and it's fun. But remember that you don't have a lot of case law then interpreting and telling you in advance what the meaning of each clause is, and so you'd better be darn sure that you're doing a good job and that it is clear to the client what it means. And so you can have a lot of fun with these, I think. I think that probably brings me to the end of my little talk. Thank you.
Thank you very much, Jerry, and we'll begin the afternoon program at 1:30. See you then.